Det syndon fradomus, de Æthelberht König sette on Augustinus die. Godes fair and Kirchen 12 gilde, Bishopes fair and 11 gilde, Prestus fair 9 gilde, Diaconus fair 6 gilde, Clericus fair 3 gilde, Chirich frith 12 gilde, Mathel frith 12 gilde.
What we have just listened to is the beginning of the earliest written English law. It's been preserved in Textus Roffensis, meaning the Book of Rochester. Known as Æthelberht's Code, the law was issued around the year 600 by King Æthelberht or Æthelbert of Kent. We saw a statue of him from Canterbury. There is also a statue of Æthelbert here in Rochester Cathedral. Æthelberht's Code is not only the oldest English law, but also the earliest datable work of any genre composed in the English vernacular, in effect marking the very moment English became a language of the page. Today we call this language Old English. It's the forerunner to our modern-day English, and many of its words have survived. More than 80% of the 1,000 most common words in modern English are from Old English. That's according to the Linguistics Research Centre at the University of Texas at Austin. Indeed, you may have recognized some words at the beginning of the reading of the law. 12 and 11, 6, God, church, bishop, priest, deacon, cleric, the last two borrowed into Old English from ecclesiastical Latin. Æthelberht's Code is in essence a series of clauses about compensation, payments to be made by an offender who had committed theft or violence against another individual or an institution.
If I are worth 50 shilling you better. If most other
Famously, it provides a tariff of monetary value for every part of the human body, from the hair of one's head to the toenails, and compensation matching these amounts is due the victim if one removes or damages the body part through unmerited violence. So, for example, if an ear is cut off, the payment is 12 shillings. But if the victim is made deaf in either ear, it's 25 shillings. If one strikes off a thumb, it's 20 shillings. A shooting or index finger, 9 shillings. The middle finger, 4, the gold finger, 6, and the little finger, 11 shillings.
If mannen avsläpp med lägger 100 shillingar i bete. If mannen avsläpp att öppna grav 20 shillingar för gälde. And in 49 en led för gälde.
Compensation was paid to the victim, and in cases of manslaughter, the so-called man price, which was 100 shillings, was paid to the victim's family. The first 20 shillings of this had to be paid quickly at the open grave, we're told. The remainder was to be settled 40 days later. In general, then, we may understand these payments as reflecting the relative loss of each injury. In a society that was based upon honour, it was permissible to take vengeance, enacting a feud, but the system of compensation allowed an alternative honourable means of settling the matter. I must emphasise, however, that it isn't possible to know exactly how Æthelberht's law code played out in real life. What we do witness, though, are the ideals of an early English king. Going back to those opening words that we heard, we see that they were concerned with degrees of compensation paid to the church and its representatives whenever theft or damage of goods occurred. You may have picked up on the repetition of the Old English word gilde, which means with payment, specifically in the sense of a compensation payment. So a violation against Godes fair, meaning God's property, had to be compensated 12 gilde, with a 12-fold compensation. Bishopes fair, a bishop's property, 11-fold. Prestus fair, a priest's property, ninefold, and so on. This emphasis on the institution of the church at the beginning of the law code was designed to integrate the fledgling church and its property into the existing legal system in Kent at that time, which, before the written law, would have been orally transmitted by experts in law, and so would have depended upon memory. Just a bit of background, though I suspect many of you are familiar with this. Christianity had only recently been established in Kent when the law code was being put into writing. In 597, a mission was sent by Pope Gregory, headed by Augustine, who became the first Archbishop of Canterbury. And Æthelberht had only just converted to Christianity, joining his Frankish wife Bertha, who was in fact already Christian, and indeed had brought with her from her homeland her own personal chaplain, a certain Bishop Leodhard. And she was worshipping unhindered in a renovated Roman building which became the Church of St. Martin in Canterbury, the centre of the Gregorian mission, and which survives today with a few medieval extensions. Now, I've already mentioned that Æthelberht's code is the earliest datable English text. In Æthelberht's day, before the Gregorian mission, Old English was not a language of the book, though it was inscribed as runes on stone or in metalwork, as you see here on this 6th century sword pommel found in an Anglo-Saxon burial site in Kent. But written English was not a fully functioning language. Augustine was no doubt responsible for helping Æthelberht and his council of advisors transfer the vernacular English into the Roman Latin alphabet, though it was necessary to invent a few extra letters to convey certain Old English sounds, two of which are actually runic symbols. The letters win and thorn. Win, like a P, standing for the sound W, and the thorn, which looks like a P with an upright or ascender, which signifies the sound th or the.
Thadomus the Æthelberht König.
All of this meant for King Æthelberht that he would become the first ruler in the whole of Britain to have a written law. And it would seem, as I've argued elsewhere, that he may have viewed this as a way of immortalizing himself in an earthly context. It is truly remarkable, I'm sure you agree, that Æthelberht's law code has survived. We don't have the original early 7th century document, it no longer exists. What we do have is a scribal copy of his compensation laws that was penned by an anonymous monk in the 1120s in Rochester Priory, the ruins of which are adjacent to the cathedral. That this is a unique copy makes Textus Roffensis incredibly important historically. But there is far more. Besides Æthelberht's laws, Textus Roffensis also has the laws of 3 other Kentish kings of the 7th century, the laws of Llothere and his conquering nephew Adrich. Their laws were at some point collated together, and that is what is preserved in Textus Roffensis, and the law code of Wihtrad, who reigned in Kent from 691 to 725. These other early Kentish laws only survive in Textus Roffensis. In total, there are in the Rochester book 35 texts that can be classified as law or fragments of law, representing 500 years of law. 27 of those are written in Old English, 13 of which are unique to Textus Roffensis. One of these is King William's Statute, or the Acts of King William, a writ in the name of William the Conqueror, dealing with suits brought by Englishmen against Frenchmen, which introduced to the English the unfamiliar option of trial by battle or combat, what we might think of as a judicial duel. The remaining laws are written in Latin, and include the earliest copy of the coronation charter of Henry I, William the Conqueror's 4th son. In this text, Henry promises, as the new king, to improve English law, to remove the unjust exactions of his predecessors, restoring the standard of law that was present in Edward the Confessor's day. Because this text also spells out the responsibilities and limits of the king pertaining to the church and the king's noblemen, it's seen as the forerunner of Magna Carta.
me luva thu otre fremde godas over mig. Ne mine namen ne ki thu on idelnesse, for tham thu ne bist und schildig with me if thu on idelnesse je kust mine namen.
Going back to the Old English laws, Alfred the Great's laws, his Dombok, his Book of Doom or Judgment, is also preserved in Textus
For them on
Roffensis.
6 dagen Christia water heavens and earthen,
As you can hear, it includes a preface with a version of the Ten
hine
Commandments.
je reste on thone 7 dagen, and 4 dritten hine je haugeday.
Most of the 8 laws of Athelstan, the first king of a unified England, are also copied into Textus Roffensis. His major set of laws, known today as the Greatly Code, survives in full in its original Old English only in Textus Roffensis. More on the Greatly Code later. All this is remarkable even before we begin to consider the collection of legal documents in the second part of the Rochester book. Yes, Textus Roffensis is actually 2 volumes bound together during the medieval period. The second part is a cartulary and contains numerous medieval royal charters and other legal texts, all relating to Rochester Cathedral. One of the most notable of these is the foundation charter for the cathedral. We know this to be a copy of a probably 11th century forgery. However, it was evidently produced to reflect the historicity of King Æthelberht's granting of land to the cathedral in 604, something to which Bede refers in his ecclesiastical history of the English people. It's probable, as Ben Snook has argued, that land charters were not actually being issued until much later in the 7th century. So, though, like many Anglo-Saxon charters, it is a forged document, we might more kindly refer to it as a retrospective foundation charter. Here we see its remarkable historiated initial R at the beginning. It incorporates what is fondly referred to as the Rochester dragon, Draco Roffensis, and it also shows, whom I've interpreted as, the figure of Christ, though we must note that his halo is not cruciform. He is trampling a lion and directing the viewer-reader with his left hand to the text to our right.
Regnante in perpetuum Domino nostro Iesu Christo Salvator.
There, appropriately, our Lord Saviour Jesus Christ is invoked, and the statement is made that a small part of the king's land is to be granted to the Church of St. Andrew at Rochester. This is followed by a boundary clause written in Old English.
Langes Wales of Northlanen to Strate, and swar erst from Strate of
The street names of which we can still discern today. Nationally important charters preserved in Textus Roffensis include copies of numerous 8th and 9th century charters by various kings of Kent, Mercia and Wessex. Here, for example, we see a joint charter dating to 801 by Cernwulf of Mercia and his brother Cuthred of Kent, granting to a certain minister, Swithun, 2 pieces of land, one of which included the use of a fishery in the Thames and 4 swine pastures. The charter is followed by Swithun's declaration that on his death, this Bockland, that is, land by royal charter, is to be transferred, along with its appurtenances, to the Church of St. Andrew at Rochester. There's also a good number of charters by kings of the English, so we're talking post-Athelstan. These include charters by Edmund I and Aethelred II, better known as Ethelred the Unready. Post-conquest charters by William I, the Conqueror, William II, or Rufus, Henry I, and several archbishops of Canterbury are also preserved. Concerning the 3 charters by Ethelred, their editor, A. Campbell, noted back in 1973 that these are excellent examples of Ethelred's very long charter, which, unusually, includes a story to show how land granted by the king had come into his possession. In these narratives, Ethelred sometimes refers to his own youthful indiscretions, and especially to the manner in which bad counsellors had misled him, writes Campbell. For example, In his charter restoring land at Woodham, which survives only in Textus Roffensis, he observes how in his pursuit of youthful pleasures he had been guilty of ignorance, ignorantiae, salubrite evaderum, and had even become ungrateful, ingratus. However, in his age of maturity, he had with his whole strength endeavoured to change his religion, as he puts it, cultum mutare studui. It's clear that both the preservation of this medieval legal encyclopaedia, the most important manuscript of its kind, and the public history interpretation of it must remain at the forefront of Rochester Cathedral's curatorial activities. In 2022, after a successful application process by the cathedral, the early English laws of Textus Roffensis were officially inscribed into the UNESCO UK Memory of the World Register as documentary heritage of national significance. Textus Roffensis now sits alongside Magna Carta, Domesday Book, the death warrant of King Charles I, and Churchill's papers. This is Britain's collective memory, as the Memory of the World programme puts it. I would like to use the remainder of this presentation to focus on a little more detail in one particular area of the early English laws: theft. I hope in my overview here you'll see how the detail in laws is remarkably rich and throws a huge amount of light onto the societal ideals and practices of early medieval England. Right from the time of Æthelberht of Kent up until the Norman Conquest, beginning in 1066, theft was severely punished. In the case of Æthelberht's laws, the victim of theft was to be recompensed by a multiple of the worth of the goods. So, for example, if a freeman stole from a fellow freeman, he had to pay a threefold compensation. But if from the king, he had to compensate ninefold. In Whitrad's law, written around 695, we begin to see that theft could even result in execution, both summary execution or by the king's decree. If man lured of slay and thefte. If a person slays a man who is thieving, he is to lie without wergild. Leger boton wergelde. Wergild, literally man price, was the value in legal terms of the life of a free person, man or woman, according to their rank. Here we're being told that an executed thief, in effect one who'd been caught in the act, was to lie dead without his wergild. In other words, his family had no right to claim compensation from the person who'd killed him at the scene of the theft. Instead of such summary execution, the thief could be brought to the king, and the king be called upon to make a decision. If a person captures a freeman red-handed, then the king should rule one of three things. Either one should kill him, or the hina man quelle, or sell him overseas, or the oversai selle, or release him for his wergild, or the hina his wergelde alese. So in the case where the victim of the theft decides not to kill the thief on the spot, there were three possibilities for the thief according to the king's order. He could still be executed, or sold as a slave overseas, an ignominious fate, or mercy could be shown and the wergild could be paid to release him. The wergild at that time was 100 shillings for the lowest ranked freeman, a considerable amount of money, for which the thief's family would likely have had to contribute. Let's hope the thief was loved by his family members and that they had the money. If poverty had driven the offender to steal, perhaps becoming a slave abroad was the more likely outcome. Remarkably, it wasn't just outright theft that could lead to severe punishment. Even the probability or intent to commit theft was punishable by death or a redemptive fine. Je fern komen man or the fremde boeten wij gange, and he thon neither ni rime, nor he horn ni blauwe, for theft he bith to proviana, or the to slane, or the to alisene. If a person who comes from afar, or a foreigner, goes off the highway, and then he neither shouts out nor does he blow a horn, he should be considered a thief, to be either killed or redeemed. Theft continues to be a key theme of early medieval law codes, meeting with very severe punishment. For example, we should note the major set of laws by King Athelstan, the Greatly Code, which I mentioned earlier, and which, by way of reminder, survives in full in the original Old English only in Textus Roffensis. A little background here. Athelstan was King of the English from 927 until his death in 939, and is considered the first English monarch, that is, the first king of a unified England. So what then does Athelstan's Greatly Code say about theft? We're going to look at this in some detail.
First, that
one should not spare any thief who is caught red-handed, who is over 12 years,
over 12 winter,
and the value is over 8 pennies.
and over 80 penningas.
And if one does, he should pay for the thief according to his wergeld. But it will not be settled for the thief, or let him clear him by an oath by that amount. If he wants to resist or flee, then one should not spare him. There's a certain amount of euphemism here. One should not spare the thief. It does nevertheless refer to putting the thief to death, as other laws of Athelstan make clear. What we see here, though, is that Athelstan introduced limits for execution. The person had to be over 12 years of age, and the value of the stolen goods at least 8 pence, if death for theft was to be considered. If you're wondering what 8 pennies were worth back then, we can turn to another set of Athelstan's laws that is unique to Textus Roffensis, his slightly later London Code. There we're told a pig was valued at 10 pence and a sheep at a shilling, that's 12 pence. The amount then for which one could be executed for theft was, though not negligible, really quite small. Hardly, we might say, an eye for an eye, a tooth for a tooth. 12 seems an extraordinarily young age at which one may have been legitimately put to death as a thief. Even Athelstan himself backtracked on this, as we shall see, since his law appears to have created an unseemly waste of youthful lives. What's perhaps even more remarkable about this law is the deep sense of responsibility placed upon those who at local level held the decision over the outcome for the thief, including perhaps the victims of the theft and those living around them. If one decided to spare the thief, not execute him, then the wergeld of the thief had to be paid. In effect, this was a fine, though if one had sufficient clout, one could swear an oath to clear the victim. As we shall see, the fine may well have been recovered from the thief's family, but still, that personal and communal responsibility to act decisively against a thief was enshrined in Athelstan's law. It's difficult not to introduce our modern perspectives on the matter, or indeed to imagine certain scenarios where the sheer brutality of the law appears to frame it as extreme and unjust. Though our own understanding of age and capacity, or legal responsibility, may be starkly different from early medieval views, it may be argued that it's best to approach Athelstan's laws with a degree of detachment. I can't help but wonder, though, how a young lad of 12, sent out by his impoverished parents to steal a sheep, might have panicked when confronted by an irate farmer and his family and perhaps neighbours too. How easy it may have been in the ensuing struggle to strike the lad down because he'd resisted. What more does the Greatly Code have to say?
If man thief on karsene je bringe.
If one brings a thief into prison, in that case he will be in prison 40 nights, and one may then redeem him with 120 shillings.
Mit 120 shillinga.
And the family will act as guarantor for him, so that he will desist evermore.
That he avra je switche.
Sparing a thief of any age meant, in effect, the locals arresting him and bringing him to prison, where he would stay for 40 days. The redemption fine, the 120 shillings, is the wergild of the lowest ranked free person at that time. The burden of the fine, which was likely paid to the local lord, may have not been met in full by the thief himself, so it's likely that his family assisted or paid it all, as well as standing surety for him that he would steal no more. What follows in the Greatly Code are more clauses about further imprisonment and paying of wergild if the offender commits theft again, including a payment of a wergild fine to the king by anyone standing up for the thief. Then we're told what is to happen to a man who has fled and hasn't been brought to justice. The family is urged to find him and bring him to the public assembly by a set date, but if they then will not or cannot bring him on the appointed day, then he'll afterwards be an outlaw, and he who comes upon him may kill him as a thief.
For theft, say they him tokume.
Do we know how these laws were realized in society? Well, there are documents that reveal specific cases of named thieves being subject to 10th century laws on thievery and outlaw. But one text, unique to Textus Roffensis, that I find particularly of interest on this matter is a modification law that Athelstan introduced in response to the execution of young people. After a king's council held in Whittlebury in Northamptonshire, Athelstan makes his feelings known. I think it's worth reading to you in translation the so-called Whittlebury modification in full, for it provides an insight into the mind of the king as a ruler, but also into events as they were reported to him. The king now spoke once more to his council at Whittlebury, and made it known to the archbishop, through Bishop Theodred, that to him it seemed too cruel that one so young a person should be slain, or for so little, as he had learned was done everywhere. He then said that it seemed to him, and to those with whom he discussed it, that one should not slay a young person less than 15 years old, unless he wishes to fight, or flees, and does not wish to submit. In that case, one may lay him low, whether for a greater or lesser offence, whichever it then might be. And if, however, he wishes to submit, then one should put him in prison, as it was agreed at Greatly, and according to the same, let him be redeemed. Or, if he does not go to prison, or none is available, that they take him under surety of his full wergild, that he for evermore cease from all evil. If the kindred is unwilling to take him out from prison, or stand surety for him, then he should swear as the bishop directs him, that he will cease from all evil, and he should stand in slavery for his wergild. If then he should steal after that, one should slay or hang him, as one would do with an older person. And the king also said that one may not slay anyone for less than property worth 12 pennies, unless he wants to flee or fight, in which case one should not hesitate, even though it were for less. If we uphold it thus, then I trust to God that our peace will be better than it was before. It's grimly amusing that the king is represented as being almost surprised to learn that execution of children for theft was being carried out everywhere in his realm, as if the people were not following his own laws on theft. But the upshot was that the king's compassion, contained as it was, kicked in, and he upped the age limit to 15, and he confirmed that there should be a 12p lower limit of the value of the stolen goods, the legal compensation value of a sheep. Alas, this didn't mean younger children always escaped death for thievery. If the child resisted capture and fled, then he could be pursued and laid low, killed, irrespective of the value of the goods. And if after redemption by wergild a child committed theft again, then it was the sword or the noose for him. We have to ask, why was theft punished so severely, from our modern perspective so disproportionately? I think we have to understand that theft may have been perceived as the ultimate betrayal in a society built upon honour. Tom Lambert, the author of Law and Order in Anglo-Saxon England, when discussing the laws of King Æthelberht, also in Textus Roffensis, makes the point that these laws concerning theft aligned with existing ideas about the social harm caused by the secrecy of theft. The punishment of thieves is a very complex subject, far too complex to develop fully in a short presentation. However, we might summarise the motivation behind Athelstan's laws on theft by going back to his final thought in the Whittlebury modification. If we hit thus ye haldeth, thonny ye live each to God, that our frith bith better than it e'er was. If we uphold it thus, then I trust to God that our peace will be better than it was before. This peace, in Old English frith, is best understood as communal, as societal peace. Athelstan refers to it as our peace. It was the peaceful state shared by one and all, a peace that was everyone's duty. Illustrating this, we saw how much responsibility was placed upon those discovering the thief in the act, and on the family of the thief in bringing him to justice. As Lambert explains, in early English laws the suppressing of theft is closely associated with this peace, or frith, as if there were a collective responsibility to remove the tyranny of thieves. We may then read Athelstan's laws of punishment for theft as both an attempt at deterrence, our peace may then be better than before, he said, but also as the king taking the lead, setting the example in upholding the peace of the kingdom. I hope, even in this brief overview of the subject of theft, we've been able to appreciate how much Textus Roffensis contributes to our understanding of early law and social order in the medieval world. There is, though, so much more that could be said. I hope, too, that we've seen that the history within Textus Roffensis is not dry history. We can, in the case of thievery, begin to perceive the brutal nature and grim reality of justice and punishment at that time. This subject is something I'll be pursuing further in a public talk in person at Rochester Cathedral on July the 9th, for which you can obtain tickets via the Cathedral website. There are many more areas relating to early medieval or Anglo-Saxon history, culture and society for which Textus Roffensis provides valuable insights. The position of slaves and other unfree people in society, the status of women, marriage and sexual mores, the lives of those in monastic and ecclesiastical orders, guilds, markets and Sunday trading, death and inheritance, to list some. There are laws and directives on betrothal and how to give an oath, laws against wizardry or witchcraft and arson, a charm to be sung in order to recover one's stolen livestock, and even an excommunication curse with a little profanity thrown in. The detail is rich. The study, translation and public history interpretation of Textus Roffensis is what allows us to both mine and distribute its treasures, and such endeavours are of great value and worthy of our support. To finish off this presentation, I thought it would be rather entertaining to engage with just one of the many moments of interpretation of Textus Roffensis via Rochester Cathedral. Back in 2014, the historian Michael Wood recorded for the cathedral the Textus Roffensis excommunication curse, delivering it with inimitable passion and style.
May he be cursed in living and in dying. May he be cursed in eating and drinking, in being hungry and being thirsty, in fasting and sleeping, in slumbering and walking, in standing, sitting, lying and working and resting, in pissing, in shitting and in bloodletting. May he be cursed in all the faculties of his body. May he be cursed inwardly and outwardly. May he be cursed in the hair of his head. May he be cursed in his brains, in his vertex, in his temples, in his forehead, in his ears, in his eyebrows, in his cheeks, in his jawbones, in his nostrils, in his 4 teeth and grinders, in his lips, his throat, his shoulders, his wrists, his arms, his hands, his fingers. May he be damned in his mouth, in his breast, in his heart and pertinence, down to the very stomach. May he be cursed in his reins and in his groin, in his thighs, in his genitals, in his hips and his knees, his legs and feet and toenails.